here for prior CLEs? So a couple. All right, so this is, if you don't know, we're doing a 6-part Trial 101 CLE series. And to be honest with you, this is one of my favorite ones, and Gabe makes fun of me every single year because he hates this one.
Well, part of it I hate.
I think it's one of the by far most interesting ones, and I was thinking today of why I'm so excited about this particular CLE, and I think it's because this is really where the rubber meets the road. So in our prior CLEs, we've talked about depositions, we've talked about experts, and we've talked about how to work your case from day one with trial in mind, with a trial mindset. How to manipulate your discovery, how to use your discovery to start setting the theme of your trial. Today we're going to talk about pretrial practice and trial strategy. So now we're to the point where we're going to trial, and this is the last step we take before actually getting into the trial. The subsequent CLEs from here on out will be the parts of trial, openings, closings, and examinations, stuff like that. But for me, I really think that this is where the rubber meets the road, and I think that this is one of the most underutilized weapons that trial attorneys employ. I think too many times we get too focused on trial, let's get going. And then they skip over this whole stage where, in my mind, you can win or lose a trial. So, to start, we're going to talk about trial motions. And I want to start talking about motions in limine. And we'll see how far I get into this before Gabe starts yelling at me. He hates motions in limine. I love motions in limine. But let's start with the basics. Can somebody tell me the difference between a motion in limine versus a dispositive motion? Or are they the same thing? Okay, let me take a step back. Can anybody tell me what rule allows you to file motions in limine?
Now let's take a vote while we're doing this. Who thinks Patrick is right that this is the most enthralling subject about getting ready for trial?
You
Motions in
haven't heard the
limine.
story yet. You haven't heard the story
Does
yet.
anybody think that's the most enthralling subject in the world? I think they're with me. Yeah,
Okay.
I'm confident on that.
I told you it wouldn't be long before he jumped in and ruined the whole thing.
Yeah, I ruined it by pointing out that you're boring.
All right, so motions, and the reason why I always say what rule allows for motions in limine is because I remember being a young associate and president of the firm coming to me before our trial and saying, file a motion in limine. I said, great. I went to the rule book and I thumbed for hours and I was like, I see nothing about motions in limine, nothing that tells me what a motion in limine is, nothing that tells me what the guidelines for a motion for limine are. There's no rule that allows for motions in limine. The rule that it's typically thought to be authorized by is Rule 16, which gives the court just inherent power to facilitate a trial and make a trial easier. So when you're filing motions in limine, they're brought under the authority of Rule 16, although there's no rule that specifically allows for them. What's the difference between a motion in limine and a dispositive motion? And this one I think is very important because I think a lot of people do this wrong. And this is one of Gabe's big gripes about motions in limine.
Well, I guess I should say, and I think, the obvious issue is a dispositive motion is designed to dispose of the case.
Or a claim.
Or a claim, that's more clear in state court. Federal court, you may have to have a whole cause of action to get rid of, but and I think that the simple reason why people get these mixed up is because occasionally there are motions in limine that, if they're granted, result in almost an automatic dispositive motion, such as you're in a case that requires expert testimony on something, and the expert deadlines have passed, you've designated your experts. If you get down to trial, you get a motion in limine, in federal court, be a Daubert motion, 702 motion to exclude that evidence based on the expert's qualifications, or that their methods aren't reliable, or what have you. And then, okay, well, the good judge grants that. Well, the obvious corollary to that is then to file a motion for summary judgment saying, well, they don't have an expert. We have the report of our expert. He's not going to say anything that supports their claim. Now we want it dismissed. Now that doesn't always work as well as my brethren on the defense side would like it to, but that's kind of what Patrick's getting at, is that you can't meld the two together.
Right.
The reason I hate motions in limine is because they are often filed over stuff that is pointless. It winds up being an exercise in burying people in paper. Now, I've been proven wrong about that, so I just barely had a jury trial on Tuesday, where we went in, and I was with a very experienced coach, I was the first chair, my second chair was a very experienced attorney, he's probably 10, 15 years older than I was, but that was his first jury trial because previously he just practiced in federal court under the FDCPA. So, Eric. So, we went to trial, and when we looked at the motions in limine, I thought, you don't really need to file that motion. That seems obvious. Well, it turned out he decided, I told him he could file them if he wanted because I didn't think they mattered. But it turns out the other side had a complete lack of understanding of, there's a dog bite case, there's strict liability cases, so the conduct of the people who own the dog and the demeanor of the dog don't matter. They're not relevant, they're not admissible. It's because years ago the legislature decided that rule you learned about in law school, that 2-bite rule, leads to these long, miserable, drawn-out trials where we have witnesses getting up to say it's a good doggy, and witnesses getting up to say he's a mean doggy, and the owners are, the legislature just decided, look, you own a dog and bite somebody, you're responsible. That's it. And then all we really have to do is determine damages. There were some other complications, that's essentially it. But we got major pushback when Eric filed a motion saying that the disposition of the dog is not relevant and no evidence should come in, about whether it's a well-behaved dog or it's trained. The judge had even addressed this in a previous motion, a discovery motion, and yet there was major opposition from the other side, and he didn't even concede it. He wasn't willing to concede it at argument. It got to the point like, well, the judge actually said to him, well, and his clients hadn't seen the incident, they hadn't been home at the time, it was kids sticking a hand through the fence. She said, we had a telephonic pretrial conference. She said, well, counsel, so this is the issue, and she's trying to explain strict liability to him, and then she says, for example, you guys don't dispute that it was your dog, but that this child. And he says, no, Your Honor, we're entitled to make them prove it, and so we're gonna fight that. And there's just this long pause on the phone. If you just got done speaking in a telephonic conference, that long pause is bad for you. And the judge was just like, okay, I guess you can do that. But there's no evidence. All of the witnesses who were there identified the dog in the backyard where the dog was. It just was very, very clear. So occasionally they uncover bizarre notions in opposing counsel's head, but for the most part, I've always said that I prefer to try cases against really experienced, seasoned, well-trained counsel because it makes life so much easier. The public assumes that if the other lawyer is terrible, their lawyer is just going to love it, and that has never been my experience. I've always having either a pro se party or somebody who doesn't know what they're doing. Don't get me started on attorneys moonlighting in other areas that they don't understand. They've got a friend or a cousin who comes in with an accident and they do tax law, but they've heard that personal injury can be really lucrative, so they want to do it themselves, and then it just gets to be messy. So, when you've got somebody who's just kind of off the rails like that, I guess it can be useful to kind of suss out their theories, but a lot of times they wind up being like, you could write the motion, you could write 8 motions, or you might write a motion that says, Your Honor, please order all parties to comply with the Utah Rules of Evidence and other laws.
Right.
Period. And when the rule gets broken, it is one more stick on the fire you can throw if there's been a specific order from a judge on this. But most of these rules, you don't need a specific motion because everybody is presumed to, all of us at least, are presumed to know things like the collateral source rule, or the fact that you can't mention insurance, or the fact that you're not allowed to mention subsequent remedial measures to show evidence of prior negligence. Like, these are basic evidentiary concepts, and if we have to start filing motions, you know, the only time I would file a motion on that when it was my choice would be if I had seen evidence that the opposing counsel either didn't understand the rule or was intent on violating it. And then I would say, okay, we need to get this on the record. We need to file this motion so that we have a ruling from the judge in addition to the rule. They've been told, they're on notice, and now we can go ahead. But otherwise, I think they're dramatically overused. Now, part of that's from the plaintiff's side. Patrick obviously said most of the time, most of the motions in limine will be filed by the defendants. And hopefully that's the case. If you're representing plaintiffs, because, and we'll talk about this a little later, I'm gonna get into the trial strategy part, but you know, as a plaintiff, you get the opportunity to select which cases you're gonna handle. And if you're doing that right, then, you know, unless a piece of evidence is confusing and misleading, you shouldn't care what comes in, because you should be confident that if the truth that comes out, your client will win what you expect them to win. Otherwise, I wouldn't take the case.
And that's where Gabe and I do agree, is that there are motions in limine, and I can say that I've never filed one of these boilerplate motions in limine that basically say, Judge, please make the other side follow the law. Never filed those. Those are a waste of time. Don't mention collateral sources. Don't talk about greed. Don't mention the McDonald's case. Stuff like that. I mean, that's just, those are dumb motions.
You'd be surprised how often that one particular one, we had 2 jurors excused in the trial because they marked down on jury questionnaires that they thought jury verdicts were too high, and then they said, oh, well, I think, you know, about that McDonald's case, and that was like, you're out.
Yeah. But I think that if a good trial attorney can use motions in limine to think outside the box and use these motions to help steer the trial, to either limit the trial in the way they want it to be, or steer the judge in the direction they want the judge to be thinking about proactively. So, again, circling back a little bit, dispositive motions are completely different. Don't use these for dispositive motions. Dispositive motions are, Your Honor, they can't meet these elements of the claim, and so this claim should be thrown out. You're eliminating a claim, a cause of action, or you're eliminating the entire case. That's not what a motion in limine is. A motion in limine is, Your Honor, there's evidence that might come into this case that should not come into this case, and here's why, and you should eliminate that evidence. All right, so I'll give you an example. I do a lot of professional malpractice defense. We were defending an attorney who malpracticed. There was no doubt. He missed statute of limitations 3 different states, 3 different times. It was bad.
I think I'm familiar with this case.
And we knew we were going in and that we were losing because we admit liability. It's a question of damage and proving the case within the case. In the attorney's notes, he had comments about the client. His client's a pain in the ass. His client's calling daily. Tell him to leave me alone. Those types of things within his notes. We filed a motion in limine to exclude that evidence. And typically when you do a motion in limine, if you're doing a motion in limine properly, it's usually brought under rules 401 and 403. All right, relevance, but if it's relevant, it's more prejudicial than probative. And that was the argument we made. This is more prejudicial than it's probative. We admit liability. We admit we malpracticed. So
that's the reason you got away with it.
The extent of our malpractice. Right, and so the extent of our malpractice shouldn't be at issue in this trial. And so bringing in this information, these notes from our attorney about the client will be prejudicial because all it will do is stoke the emotional fire of the jury. And it provides no probative value because we already admit liability.
Well, and there's an important distinction there, and I think this is really, you know, what's been said plus this is probably all you need to know about motions in limine is from the Latin words, you know, the in limine is at the door, okay? So it's stuff that you want to prevent even being mentioned at trial, because otherwise you can get up and, you know, you can obviously whenever they do something, they say something, you can jump up and object and the judge can strike it. But some things are so prejudicial that if the jury even hears that they exist, it changes their, you know, mean, if a plaintiff's attorney could ask, the defendant on the stand, like, well, don't you have homeowner's insurance that'll cover this? Well, even if there's an objection, that idea has already popped into the jury's mind. Now, keep in mind the jury already knows this. They will discuss it. At least somebody will bring it up in the jury room. Hopefully, some of their other jurors will tell them, "Hey, we can't talk about that. The judge says we can't speculate on things." But those kind of things are things that I've found motions in limine on, where you have an issue that you know or suspect the opposing counsel is going to bring up that is so prejudicial that the damage done by the jury even hearing the question is greater than the benefit of you getting up and having them shut down.
The bell can't be unrung.
Right. I mean, we made, for example, in this particular case, because that I'm using as an example from the other day, we made the strategic decision that, we were going to waive recovery of any medical cost because the amount of the medicals was low. Juries tend to anchor to any number they're given and just go after the emotional damages. And so they weren't allowed to bring in the medical bills. They can still talk about the medical records. Now they forgot that they're hearsay, and so the judge promptly threw them out as soon as he tried to bring those up as well. But the point of it is, if you know or suspect that they're going to head down a particular track, and you think just telling the jury that will stop them, great. On the other hand, because of the circumstance of this case, we knew that the defendants did not really have. They thought they had things they could say that were relevant and that would help them, but they really didn't. They didn't have anything. I mean, they weren't there, and anything that they had done, or anything their dogs had done, or anything about them or their dogs had already been ruled that it wasn't relevant. And so, my co-counsel and I were talking. We were thinking, well, if he calls either of these people, we stand up and ask for a sidebar and say, Your Honor, these people shouldn't be allowed to testify because they don't have anything relevant to say. And I thought, no, it's much better if you let him get up there, and after they say their name and where they live, and they start asking questions, just start objecting. Your Honor, relevance, we've dealt with this, sustained. And after about 5 questions of that, they'd sit down. Now, wind up that he figured out that this was gonna happen late in the trial, and wound up not calling any witnesses at all. I figured by that time he already knew that he was kind of hosed. But that is the kind of decision you've got to make, strategic decision about whether or not to file this motion because the danger will be too much, or can I let this guy blunder into doing something ridiculous and looking like they don't know what they're doing or they're not prepared in front of the jury. All of what we're talking about, all of what we discuss has to be looked at in the context of, what will a jury think if they hear this, if they see this? What is their response? And oftentimes it's not what you'd think. I mean, if any of you get a chance to try a jury trial and they say at the end, if any of the jurors want to talk to the attorneys, they're free to do so, but they don't have to. Any of the jurors who are willing to talk to you, take them up on it, because you'll learn things that they noticed, things that they cared about, and impressions that they got from stuff that you thought was just inconsequential, didn't matter, just didn't, wasn't a concern to them, or that you thought wouldn't be a concern, and they, took something big out of it. So, that's motions eliminate.
Yeah, I got one more. I got a couple more points I want to make about a motion eliminate. And Gabe hates this motion. I've done this motion already.
Are you doing the reptile thing?
No.
Okay. That's such a waste of time. Motion.
A motion in limine that I filed, and I just finished a week-long brain injury trial, and I filed it on this one, and I think it's only the second.
The motion eliminating a bench trial?
Yeah.
And you thought that was gonna work?
Yeah, and here's what it is. And I've only filed this maybe 2 or 3 times in all the trials I've done, so I'm not saying do this in every trial. But where it's fitting, I do a motion in limine. It's titled "Motion in limine to set the scope of trial." And Gabe hates this.
It's totally improper.
But it's extremely effective, especially in a case where, so for example, in this
First of all,
brain injury case.
it's a misnomer because it's not a motion in limine. What would you classify it as a Rule 16 trial motion rescheduling? It's not a motion in limine.
I file it under the same rule that I file a motion in limine.
Well, yeah, it's
There
Rule
is none. There is
16,
none.
which is just basically like, if you need it, ask for it, maybe the judge will give it to you.
So, this brain injury case, the other side's asking for 5 or 6 million. We're saying we admit liability because they suffered carbon monoxide exposure. There's no doubt they suffered carbon monoxide exposure. There's no doubt they suffered a significant amount of carbon monoxide exposure. The argument was whether or not that carbon monoxide exposure had resulted in a brain injury. And it was a difference of $5 million on their side versus a couple $1,000s on our side. I filed a motion in limine to set scope of trial. Again, we conceded liability. And they had 3 days worth of witnesses for liability, not damages. And their intention purely was, we're gonna bring in person after person to talk about how high these levels of CO were and how high their carboxyhemoglobin level was when they went to the hospital. And we're gonna, how many hyperbaric chamber sessions they had to have compared to a normal person. They had all these people talk about this.
How is that not relevant to damages?
So that's where so I filed a motion in limine to set the scope of trial. And my motion was, Your Honor, we've conceded liability. None of this is relevant. If you want to bring them in for damages about how many hyperbaric chamber sessions they had to have, for the price of it, sure. For the medical bill of it, sure. But having people come in talking about the maintenance of our boiler and what our hotel did to maintain the boiler and what they did, none of that's relevant. None of that is relevant to this case. And as Gabe mentioned, it's a little bit silly because it was a bench trial. Plaintiff had failed to ask for a jury.
And
this would have been a different case.
First, so that you know, in bench trials, everything generally comes in.
Right.
Because judges think they can weed out any potential prejudice.
Exactly. And so I knew by filing this motion in limine, the judge was going to provide some leniency and let everything in. And then at the end of the trial, he was going to cut out what was superfluous and what shouldn't be considered. But I filed the motion intentionally because I wanted to set the stage for trial. I wanted to set the stage. I wanted to put the judge's mindset on, okay, this is really what this case is about. It's not about what the hotel did or didn't do. It's not about what our maintenance people did or didn't do. It's purely about is there really a brain injury here? And it was interesting because not only did I feel like that helped with the judge and steering the judge the way I wanted the judge to go through the trial, it was interesting that a plaintiff counsel also reacted to that motion because I feel that he was changing significant portions of his trial plan to try to combat the impression I had left with my motion in limine. And anything you can do to knock the other side off of their game and make them start second guessing their strategy is beneficial. So again, not a motion I file all the time, but I found
perhaps unethical, but
it's okay. It's not like this is
nobody's
ever gonna.
Yeah, nobody's ever find out. There's only 2 cameras in the room.
The last thing I'll mention before we leave motions in limine is, and I say this with a bit of caution, because if you want to read, there's a very well-known Supreme Court case that deals with this, but motions in limine that are ruled upon before trial are not set in stone. A judge can always still change his or her mind at the time of trial. So if there's a ruling that goes for or against you, keep that in mind when you're in trial. If it goes against you, for example, you still want to raise that at the time of trial. See if you can get it back in. Because what happens is you start going through trial, the judge hears evidence, it might change her opinion about how she previously ruled on her motion in limine. Now she might say, well, no, now that I see how it ties into the case, yes, there is more probative value than prejudicial effect. I'm going to let this information in now.
But you better make sure you make the motion in advance and you do it outside the presence of the jury.
Right. So when you decide to try that, you put in your evidence, you build your blocks around it, right? And then when you get to the point where you think, okay, I've got enough, I think that I can bring this in now, I can get the judge to flip-flop on her previous decision. You say, Your Honor, can we approach? Can we take a break? You do something. You don't do it in front of the jury. You don't ring the bell and then ask for forgiveness afterwards. That's where you'll get in a lot of trouble. You take the judge and you say, I think we can bring this in now. And even if they don't, even if they uphold their prior ruling, now at least you've got it on the record. I've had cases where we've done extensive motions in limine before trial. We go into trial, we don't really raise it again at trial because we're just complying with the former rulings. And then we come up on appeal and we realize it really would have been beneficial to get it on the record a second time at the time of trial. So motions in limine aren't set in stone. Challenge them, but challenge them appropriately and outside of the presence.
And this is, as we get more into the nitty gritty of trial practice as this goes along, there's an important distinction I want to make, and Patrick unknowingly brought this up, and I think he probably will agree with me. No, I think he'll agree with me, is that
simple minds are so easy to manipulate.
That's true. That's true. I'm very simple. It's one of the reasons I win so many of my trials. You should try it sometime. Anyway.
Do we have to bring up the only case we've had together?
You mean the one you weren't involved in? Yeah.
Sorry,
But, yeah, we can bring it up. Is that you'll always hear attorneys say, well, you get it on the record, okay? Or you want an opportunity to make your record, okay? And any appellate attorney that you deal with will go on and on about how critical this is and that you need to do it. If you're dealing with a big case or where you think there's going to be a lot of appealable issues, I'd almost have a separate lawyer, back in the gallery to make sure and let you know, hey, this issue is possibly important. You need to make sure that you preserved it and go back up there and say, hey, Your Honor, we have some more things we need to say about this. A lot of younger attorneys, when they first go into trial practice, get those two concepts confused. The concept of, well, we got it on the record, we got the evidence admitted, and the jury heard the evidence, and the jury believed the evidence, okay? The jury doesn't get a transcript of trial when they go back into the jury room, and they don't get a checklist other than the verdict form, which is the most complicated checklist that anybody can come up with, to go through and be like, oh, here you see where this attorney mentioned this, yep, he got it in, it was in the record, okay, and then they go through the whole thing and like, well, they got everything in the record, I guess they win. That's how jury trials work. In this series, we're going to focus on trial work, and we'll throw in occasionally the warning like, hey, you better make sure you preserve issues so you can raise them on appeal, anything like that. But I don't consider myself an appellate lawyer. Patrick does more of it, but that's not really what we're about here. So the question isn't, did you get it on the record? The question is, did you make your point in a way that's going to convince the jury? Are you going to win the trial? One of my favorite presenters on trial topics, Roger Dodd once said he ran into somebody who was on his jury in the supermarket, and she said, I didn't vote with you, but if I ever got in an accident, boy, I'd sure want you to meet my lawyer. And he said he didn't say it to her at the time, but he said, I don't want to be your damn lawyer. I don't want your business. I want your vote. I want to win. And that's really what we're about teaching, is how to win. There are some other things. This class, this series isn't obviously exhaustive of everything you'll ever need to know, but we're hoping we're teaching you how to win, and that you as lawyers can figure out a lot of the technicalities that you'll need to know in order not to commit malpractice if your case goes up on appeal.
All right. So let's move on. Trial day. First day of trial, jury selection. For me, jury selection is a fun topic as well. It's still a little bit more boring as far as that.
Can I address something before this that's more fun?
Sure.
Okay. You're going to a jury trial.
It's more fun.
Oh, just wait. You need one or more trial boxes, okay? And everybody likes theirs set up differently. I like mine to be full of snacks, to have some beverages in there. If you're in federal court, they'll actually usually give you your own little conference room that you can have for the length of the trial. Each side, there's 2 of them outside each of those courtrooms, and it's awesome because you can just set up all your materials in there and leave them and use it as a war room when you're on breaks and everything, and have sandwiches back there. But we'll, in the trial box should also be all the supplies you're gonna need and everything you might need. Sharpies, highlighters, extra pens, extra cords for your text stuff, backup text stuff if you've got it and you can afford it. I will say, going old school and with poster boards is fine where you've got no other options, but juries today expect that you're going to make use of the technological capabilities in front of you. It's one of the things I'm going to talk about a little later when it comes to strategy, about what the jury's perception is of how prepared you are and how much you care about your case. But getting that trial box set, and if you've got staff that can assist you, that's really great, because a lot of times you can be like, all right, I need these orders, these motions, extra copies of exhibits. If I've got my exhibits blown up on poster board, I want little paper copies in case that doesn't work and I have to hand them out to each individual juror. Extra stickers for the exhibits in case something comes up you need to mark right there. Pretty much everything you can think of. And sometimes this is one box, sometimes it's 2 or 3 bankers boxes full of stuff. We're in a multi-week trial and we're stuck in the middle of nowhere doing it. But yeah, definitely you don't want to be trying to figure out your closing argument. I mean, this week we had it turned out supposed to be a 2-day jury trial, and I was going to do closing arguments. Turned into a 1-day jury trial because the defendants didn't put on a case. And so the judge said, well, counsel, can you maybe be ready to close in half an hour? And I had a little outline together of what I wanted to say, but I hadn't practiced. I didn't know where I was going to stand. I didn't know what I needed to emphasize. And yeah, Your Honor, sure. And so we go out and, have to slam through and get ready in that time to get up and make the case. So, the big thing about war and trials is that you always have to expect that nothing's going to go exactly as you planned, and you need to be prepared.
Yeah.
And the trial box, it may sound frivolous, but actually having extra stuff in there has saved my butt pretty much in every trial that I've ever had.
I noticed that in discussing the orders in limine, that you also had on here that violation of an order may be grounds for mistrial. Have you guys ever, how common is that? Have you ever seen it? And what happened?
It's the case I mentioned is probably AHC versus
Wilson versus IHC, is that the one you're thinking of?
Yeah.
There wasn't a mistrial.
No, but it's got the violation of motions in limine and.
Sure, yeah, that one went to verdict because the judge refused, I believe the judge refused to declare mistrial. And a lot of the misconduct wasn't known until after the trial was over.
Mistrial is a pretty extreme remedy, but it does happen. And if there's intentional violations of a motion in limine, the trial I had last week, this particular plaintiff counsel had a prior trial for this same client, the same plaintiff. And so I pulled up the transcripts of that prior trial, and there was a break in that trial because he kept intentionally violating a motion in limine, and Judge K was trying to determine whether or not he wanted to grant a mistrial and shut down the whole thing. So it's very harsh. I wouldn't say it's regular, but I don't think
it
judges
happens.
are afraid to pull the trigger if they need to.
And here's the thing, a lot of times it's not used because the client doesn't want it, because they say, no, I've been through, and usually the conversation that we have is, look, this happened, so-and-so said this is now in the jury's mind, they're aware of something they're not supposed to be aware of. You run some risks if you don't make a motion for a mistrial, because, I believe you may waive your right to insist on a new trial on that basis if you lose. So it's kind of a gamble. I mean, a lot of times at the beginning of the case, clients think they're winning, whether they're on the side that ultimately wins or not. And I would say we need to be better about preparing clients for that possibility. Like, look, the most important thing here is that we get a fair trial and the truth, that gets to the jury. And, anything that interferes with that, it may be worth getting, moving for a mistrial. And I think there's a lot of times where the reason a lot of mistrials don't happen is because there was a lot of cases where the judge knows because of what counsel for the other side did. If you ask for a mistrial, he or she's going to have to grant it, and the lawyer just doesn't ask, and then you go through the trial and you lose, and you find out, well, the jury was aware of this, and everybody assumes that people can put away their biases or their knowledge that they know that they have, they're not supposed to have, but they can't. No one can. And so, I try and prepare my clients for that possibility. The one time I can think of is a criminal trial I was trying where there was a key piece of evidence about an altercation. We got to the last witness of the day, who was the alleged victim, and she said she had videotaped the encounter on her cell phone. And we had heard this, but nobody had been able to find the video. The prosecution was claiming they didn't have it. And, it's right before we're gonna get submitted to the jury, and I'm thinking, we're in trouble. And I asked her, okay, well, you had this video, yes. Where is it? What'd you do with it? And she says, oh, I emailed it to that police officer right there, who was sitting at the prosecution table. And everybody in the courtroom just kind of went. And the judge, on his own, says, ladies and gentlemen of the jury, we're gonna need to have you on the back. We need to take a break for a minute. It was like, there's a recording of the incident that everybody's arguing about what happened, and it's never been turned over. And so, the judge was like, he gave us an option of whether we could go on with a really strongly worded instruction, or we could take the mistrial. And, it was a very clear, easy answer to that question. We took the mistrial. But
yeah. And I feel like whenever it's a mistrial due to a violation of a motion in limine, it usually doesn't get that far because the judges will immediately say, you're telling the line, counsel, I've already talked about this, and chastised throughout the process. And so you really have to be intentionally going in the face of the judge. And if that happens, you probably have bigger concerns than the mistrial. The judge is going to report you, and you're going to.
Well, and I think all that's true. I just think there are some issues and some topics that are so prejudicial that if they get out to the jury, the bell simply can't be unrung, and there just cannot be a fair trial. An issue the defense would care about a lot is probably the existence of liability insurance, that the defendant has liability insurance that'll pay the verdict. For the plaintiff, an equivalent issue would probably be the collateral source rule. I mean, once the jury's heard that these $1 million in medical bills, most have been paid by health insurance. There's no way to unring that bell and get a fair trial out of that. And I think almost as a matter of law, once that's happened, there's no way to fix it. You can't without declaring a mistrial and getting another jury.
So it sounds like if it comes out from a witness versus behavior of the counsel.
Depends on the issue.
Yeah.
It depends on the witness too, right? If it's your company's representative, that it should,
it should know. And
yeah. But if it's just a fact witness that you don't have any control over.
I mean, a little bit of it is the misconduct of a party, but I think the larger issue of the motions eliminated, or the motions for mistrials that get granted, is more focused on the prejudicial effect, on the inability to do anything to fix it. I mean, a finding that you broke a motion to eliminate or one of these key rules intentionally is going to get you referred to the bar by the judge for an ethics violation, but an issue that the jury just now can't decide the case fairly and unbiased is what's going to get you a mistrial like that.
But that's a great question. All right, so going back to jury selection, you've probably heard this before, but in my mind it's a misnomer. It's jury deselection. You're never picking your jury. You're eliminating the people who are the worst for your jury. And there's it's so much fun to talk about jury selection, jury deselection, and voir dire, and what questions you ask. And if you get into a jury trial, you'll spend every break and every lunch saying, I think juror number 6 is on our side, but juror number 3 doesn't seem to. And at the end of the day, you'll realize you had no clue. That it's voodoo, nobody knows, and You know, we've had cases where we've brought in nationally renowned jury consultants who have sat there and given us opinions about selecting the jury. And when I hear their opinions, I think, I already thought that. There's no magic here. You know, this is just someone trying to read a bunch of strangers the same way I would read a bunch of strangers. So, but when we're talking about jury selection, there are times, and that's why it's jury deselection, that you can identify people that you do not want on your trial, depending on what position you're in. So when we're talking about jury selection, when you're asking for dire questions, you're not looking to get people to agree with you, you're not looking to convince people to your side of the story. What you're trying to do is identify the people who disagree with you and are never going to change from that position regardless of what the evidence might be. When I was in law school, my trial ad professor, he was in a different state, so he practiced in a different state, but his position was, in voir dire, I don't ask any questions. I don't want the jurors to talk. This is my first chance to sell my story. I'm going to do 100% of the talking. I don't care what their opinions are. I'm going to tell them what their opinions are. And I remember being young thinking, oh, that's great, that's aggressive. But the more trials I do, the more I think that's not realistic. Yeah. I'm a stranger, they don't trust me, they're not going to change their opinions.
Yeah, it gets pretty arrogant to think that, and this goes to, you know, there's kind of a shift going on in Utah courts and in different courts around the country about attorney conducted voir dire. And you have a lot.
Do you ever do
judgment? Judge Scott was very adamant that she. Yeah, which I mean, I can see the point of the judges that, I mean, so almost every judge in the state will allow it, with a couple of exceptions. I know there's one on the federal bench who won't, but with a couple of exceptions, every judge will let you question each juror in chambers, and let both parties question just about every judge that I've been in front of. When I say attorney conducted voir dire is when, you know, the judge will ask the preliminary questions. Are you a felon? Are you, 18 years at least? Can you read and understand and hear English? The basic qualifying questions. And then they'll say, all right, counsel, what questions do you have in the panel before we start bringing people back? And the beauty of this is it helps to set the tone, and it helps to get your get jurors feeling set the tone of voir dire, and get the jurors feeling more comfortable, because the arguments against attorney conducted voir dire are assuming that the reason attorneys would do this would be to try and plant some subtle idea in the jurors' minds, or have some other juror say, well, I think this, and then it would somehow poison the whole jury. And at this point where they know nothing about the case, that's really not possible. I mean, you'd have to be talking about a very weak-minded individual that could hear something either from a stranger, a lawyer, or especially from one of their, fellow members of the venire, that would suddenly say, gee, I believed this for 30 years, but because this one guy made this one comment, now I believe the opposite. I mean, people really don't change their opinions that way. And when I get the chance to do it, the atmosphere I want to establish is actually the opposite. I want the jury to feel extremely comfortable about telling me things that otherwise they might be embarrassed to say. I'll be like, hey, who here thinks, usually that where there's smoke, there's fire? Am I right? And, there'll always be some jurors that'll raise their hands, and I'm asking really the opposite of what I'm, especially if I'm defending someone or something, or I'll say, who here just thinks that some people, aren't as trustworthy as others, and, who here tends to believe a police officer more than a regular person, somebody in authority. And I want them to, and I kind of use my voice in a way where I'm trying to make them feel comfortable, like, gosh, everybody's got some bias, it's true. Everybody's got some prejudice. So just tell us what it is and it'll be okay. Nobody's gonna judge you. And, you know, we'll ask these things. And, you know, the more sensitive stuff will come up only back in chambers. But, you know, I'll try and ask some kind of initial sort of disqualifying questions. Like, you know, who here thinks that if somebody's going to take somebody to court, they better be like 80 or 90% sure that they're right on each of the issues? And, you know, there's always hands that go up, and we'll note down who it is, so that later, if it turns out that this is not someone we think is going to be receptive to us, we can double down on that back in chambers and say something like, now you said this out there, so you think it's really important that you know, in court, people only come to court when they can prove things, you know, 80, 90%, right? Yeah, what about if somebody only can prove something 70%? What if they could only prove it 60%? No, I just don't think I could ever, you know, agree with that. Not even if, you know, you were told that there was some other standard, well, I'll follow the law, but I just, you know, I think bringing somebody to court's a really big deal, and if you should only do it if you're really, that's a really serious thing. Okay, well, that person just got bounced from the jury, because obviously the standard is more likely than not in a civil case, and they've just said that no matter what the judge tells them, they're always gonna have a problem if they're not 60 or 70% sure, not 51. And so, you know, that has been a convenient way. We've gotten some people bumped from juries before when we thought, without having to use a preemptory, because we thought, well, you know, if they're not willing to accept a fundamental premise, you know, and it's also helpful because occasionally you're gonna encounter what I call stealth jurors, which are people who, especially, anybody here a plaintiff's lawyer? Plaintiff's lawyer, couple? Okay, we have 3, all right.
Way to shame them in public.
These are the true Americans, my friend.
These
These are those that would stand on the front lines in the Revolutionary War. You guys would be back there and be like, no, the English ain't so bad. They got a cool accent. Old lady in a big house, sure. You know, we'll encounter stealth jurors. And, you know, I wish I could tell you it was a rare thing, but it happens in almost every trial, where there's somebody who's a super tort reformer, okay, who thinks that lawsuits are the devil's handiwork and that they need to be stopped at all costs, and they want on your jury. They hate lawsuits, they want to kill them, and they really want on your jury so they can sit there and scream at everybody else about how unrealistic everything is, and all the notes they're taking. I mean, I'm dead serious. You get a cross section of 50 people, 100 people. There are going to be a few stealth jurors in there, and they'll answer their forms in ways that are really ambiguous and not a lie, but they don't really. And then when you ask them about the more problematic stuff, they'll walk it back, you know, and try and do it. And it can be really hard to get these people to express enough once they know what the standards are that they're going to be required to hold up to, and what they know, once they know what the rules are, to get them to admit that they're not willing to follow those rules. So a lot of times attorney-conducted voir dire helps to ferret that issue out in a way that is frankly really fair. I mean, if somebody says they're not willing to do something that is the law that they're going to be asked to follow, then they should be on the jury, period. Whether they knew about it and had a chance to plot an answer around it beforehand or not. So, you know, that's my pitch. If you're ever in court and a judge asks you, well, what do you guys think about an attorney-conducted voir dire? Never give that option up, because it can give you some, like I said, some amazing insights into your jurors.
Yeah. Well, and as Gabe mentioned, I think the first dozen or so jury trials I did here, you weren't allowed to do attorney-conducted voir dire.
No, it's gotten to be, it was a big thing way back in the day, and now it's gotten to be a big thing again.
Yeah, and then I would say the last 3 years, every trial I've done has been attorney-conducted.
Yeah, I was surprised that Judge Scott was, I mean, she was pretty adamant about it. Which, you know, I mean, there's this school of thought that is there.
So, when it comes to voir dire, I think there's 2 very useful bits of advice and information and tactics. One, Gabe mentioned when he said, where there's smoke, there's fire. I think that voir dire is a good chance to, and we're going to talk about this in the second half, is a good chance to start introducing your theme. You can phrase your questions to start introducing the key phrases, the key words, the key theme that you're going to implement through the rest of your trial. It's your chance to introduce that concept. The second one that Gabe mentioned also that I want to come back to is when you have someone flip out and say something completely against your position, that you feel, oh man, this destroys my case, as Gabe mentioned, it's not gonna taint the jury pool. If you're sitting next to some stranger and some stranger spouts their opinion, it doesn't change your opinion.
I mean, in the rarest case where there's somebody who is in the jury pool, usually by the time you get to it, they've eliminated everybody that, like, the judge will have asked questions like, any of you know any of the parties? Any of you know anything about this dispute? Any of you, ever been represented by these attorneys or their law firms? And so you're ruling out everybody that knows anything relevant. And so if they spout out off, nobody's gonna take you seriously. That's very different from a witness dropping something in that's specifically relevant to the case and then doing it out. One thing I did want to disagree with Patrick about, because that's one of the reasons I'm here, is I don't think that voir dire is necessarily a good time to start introducing my theory of the case. It's actually the opposite. I'm trying to find those jurors who disagree with me. And so why would I, in doing that, say, hey, ask a question that the underlying premise is, don't you agree with this extremely reasonable proposition? Because if I've stated that right, the answer is always going to be yes, and I'm going to get nothing. I want to know, hey, who here thinks this is just crazy? And get them to raise their hands and let me know, okay, these people already have told me that they think it's crazy. I'd be very suspicious of anybody who really wants off a jury or anybody who really wants on. But yeah, I don't typically, and that is the fear behind why a lot of judges don't like attorney-conducted voir dires, because they assume there was some very early back when they were suggesting, let's do more of this. There are some ideas that you could plant ideas in the jury's head by going to your theme. I still think it's the same principle as, if somebody blurts something out, it's not going to taint the jury pool. None of us are Jedi Knights, regardless of whatever videos Patrick has made of himself in his garage. None of us have mind control. We can't,
YouTube likers.
What?
1,000 likes on YouTube.
There you go. That's your metric. I can't go, you will agree with the plaintiff. This person was incredibly injured. I mean, it's just not. The whole purpose is actually to ferret out those people who just will not ever accept my theory of the case because of some preconceived bias, and get them to admit it and stand by it. So that when the judge tries to rehabilitate them by saying, despite what you've said, do you think you could set those feelings aside if I instructed you to, and and decide this case impartially? It gets to a point where they've doubled down on it enough that almost every judge realizes that that they're not going to be able to rehabilitate this juror, so they have to kick him.
And ferreting out, that goes into the second tip. So when you have someone who explodes with a position that's against your position, you're never trying to convince that person. What I immediately do is I start scanning the rest of the jury pool to see if there's anybody else who's nodding in agreement and help identify other. I already know that this person either is going to be off my jury for cause, or I'm going to use one of my peremptories. So I'm not worried about this juror anymore. Now I'm scanning the rest of them to see who agrees with that, who disagrees with that, to identify other jurors.
Well, if I have a free enough hand from the judge, I may even say, who here agrees with this gentleman? Which one of you guys agrees that he's right or has those same feelings? And you'll get a couple of hands, because people feel more comfortable when there's more of them standing out, and then you know who's going to get stricken. You know where to go.
So before we go on break, I want to do one last thing that I always think is kind of fun, and I think that a lot of attorneys don't get to do, and so they don't understand, and that's the two different types of jury selections that are allowed under Utah rules. You can read these in Rule 47, but Utah has two different, and I've had judges use both types. One is called strike and replace, and the other one's called stricken. So, and I wish I would have brought in a whiteboard. It's a little bit easier, but if you picture, you've got your judge, so let's talk first about strike and replace.
Just draw it up on their own Sharpie, no one will.
Nobody ever has.
Yeah, they won't, I think I noticed, but they won't mind.
If you picture the judges bench is up here, jury box is over here, plaintiff usually sits by the jury, defense sits away from the jury. They'll bring the jurors in, and they'll fill up the peanut gallery with 60 people, more if you've got a case you think that's very popular or might have more for cause. People stricken, and they all sit in the back. Judge will call out the magic number, which is, depending on your trial, is about 18. And when we get to that number by
State court, it's
state court would be
14 plus maybe 2 alternates, depending on how long the trial's gonna go.
All right, so let's
Maybe
talk.
60.
So we're all starting from the same position. If you're doing a civil if you're doing a civil jury trial in Utah, if it's a longer trial, you're gonna have if you get 8 of 6, right? You need to win 8 of 6 jurors. If it's a longer trial, you'll each get enough. You'll get 2
You need to win
alternates.
6 of 8.
6 of 8. Is that what it is?
You
Did I
said
say 8 of 6?
Yeah.
I'm so good. I aim for 8 of 6.
He gets the extra ghost jurors that are haunting the courthouse.
I'm like, not only did I convince all the jury, plaintiff and his paralegal also agree with me, so that's 8 of 6. So you're looking for 6 of 8. If it's a longer trial, you're gonna have 2 alternatives. So you're gonna have 10 people in the jury box throughout your trial. At the end of the trial, the 2 alternates get dismissed and you're left with the 8. So at the end of the day though, you're gonna need 10 people in the box. So the way I get to 18 as the magical number is, if you've got an alternate under the rules, each side gets 4 peremptories, all right? So that means you have a total pool of 18 people sitting in the jury box that are your potential jurors, under strike and replace. You got 18 people in here because 10 are ultimately gonna be your jury, 4 aside are gonna be stricken for peremptories. So you got 18 total. You start asking your questions while the rest of everybody's sitting in the back listening. If someone comes up that's stricken for cause, they've got some bias they can't get past, they know somebody, something like that, they're excused. Judge calls another name randomly who comes up, sits in their seat. You're always just addressing the 18 people in the jury box. You're not addressing the other people in the crowd. When someone comes into the crowd new, you say, you've heard all the questions we've already asked. You have any responses to that, and you try to get that person up to speed, but you still go forward with only questioning the 18 people. When the 18 people have passed for cause.
Whenever I've done it, and especially if they allow an attorney voir dire, and with the general questions, the judge will ask, and will have you direct the questions, or have me direct the questions to the entire venire, so we don't have to go back.
Oh, really?
Yeah, just because it's tedious to.
And I admit to this strike and replace, I've probably only done 2 or 3 times. That seems the less popular of the 2. Yeah. When it's passed for cause, when you've got your 18 and everybody has passed for cause, nobody's going to be stricken for cause, and you're down to your 18. Then you use your 4. Then starting with plaintiff, they use their first peremptory. Defense, plaintiff, everybody uses their peremptories until you're down to.
Which is a really awkward process, because usually you've turned to face, the judges have you turn to face the jury, so you're on the opposite side of counsel table, and you're looking at the jurors, and the bailiff is bringing this sheet, and the jurors know that this sheet's got all the juries, their names on it, but they don't know which ones, and they see you looking, checking your notes and talking with each other, and then they see us draw a line and then pass it over. And it's almost like they're all sitting back there going, like, please, strike me, strike me, strike me, strike me.
And give little kisses to the ones he strikes. All right, so then the other one is stricken. Stricken is the whole jury pool comes in, they're all sitting in the peanut gallery. Judge tells you to wheel your chair around to the other side of counsel table so you're facing everybody that's in the jury pool. Jurors don't know this, but the attorneys do. They're numbered 1 to 60 or whatever, with number 1 starting in the left-hand corner, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15. So you know the number of all the jurors in the pool. And so if these benches are the peanut gallery, if you know that there's not going to be a lot for cause, a lot of people stricken for cause, again, you're looking at mostly just the first 2, maybe 3 rows. You don't care about the last 3 rows of people. They're never going to make your jury. So you don't care what their answers are. You don't care what their opinions are. And they don't know that. They all think they all have an equal shot of being on it. But you know that 18 plus how many ever for cause people, that's your jury pool. And the rest of the room doesn't matter.
Although I will say I have seen some particularly, let's say the two visions. This particular attorney would say he was being zealous, and everyone else would say he was being an ass. Likes to challenge this other attorney likes to challenge every single juror for cause. And I know that he's done a med mal trial in Duchesne, and out in places like that. Here they'll call back 30, 40, 50 people. Out in small towns, they'll call back 150 or 200 people because everybody knows each other. So there's a lot of people who get excused. And in that case, I heard from the judge that they got down to 2 jurors left. So they finally seated a jury at 9 o'clock at night.
Yeah.
Yeah.
We had a trial in Beaver, same thing. Who
Yeah.
knows who in here knows plaintiff? Half the room raises. Who knows defendant? The other half raises their hand. You know, we've done a trial in Brigham City where we were suing Thiokol. We were plaintiff on that one. Suing Thiokol, and who here works for Thiokol? Everybody raises it. You or your spouse works for Thiokol. Everybody. So you will have places where you have to bring a much, much larger jury pool just because so many people will be stricken for cause. If you're doing it in Salt Lake, typically, that attorney malpractice case we had, I think, a jury pool of about 80 because he's a well-known attorney on commercials and stuff, so he's a well-known attorney. But most likely you'll have 40, 50, 60 jury pool, okay? But again, you're only worried about the first 2 or 3 rows. So it goes back to my tip of if someone in the back says, I think that lawsuits are frivolous and nobody should ever get any money and if you're plaintiff, you don't care about what that guy in the back row is saying, you're looking at the first 2 or 3 rows to see what their reaction to his comment
Well,
is.
and I care about, because I'm gonna turn around and ask everybody else, you know, does anybody here feel the same as this gentleman over here? And again, the key to attorney coming back to voir dire is to really strip yourself of judgment. Because if you're judging the jurors for having, you know, backwards, racist, homophobic, biased, you know, tort reform, you know, improper opinions, it'll show. And it makes people want to trust you less, especially if they're intentionally trying to get on the jury. And it makes them want to be less honest with you and with the judge. And, you know, it just doesn't work as well. So you've got to be like, hey, you know, we all have something that drives us crazy. Who here just thinks that there's just lawsuits are just out of control? And you have somebody like, I think people sue over nothing. I say, okay, who else here, raise your hand if you agree with what he said. And, you know, sometimes I'll get hands, sometimes I'll get another person who'll say, yeah, I agree with that, blah, 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 blah. And it's like, okay, anybody else agree with that? And we keep going until I've identified, you know, everybody on the jury that I've got usually either an associate or a colleague or my paralegal back there keeping track of who said what, so that when we go back and I pull up their sheet, I can say, okay, well, let me ask you some questions about what you said before, and, you know, guide things from there.
All right, so
Well,
wrap it up, and then we're done. So you get your group here. Again, you know that number 1 is sitting right here in the front left side, and you're numbering from there. So say in that first 20 people, 3 have been stricken for cause. You know you're only looking to juror number 21 and before. Nobody past 21 matters. So when you start doing your peremptories, again, you pass it back and forth, you're only striking, and this one's less awkward because the whole jury pool thinks you're striking from amongst all of them, but in reality, you're only striking from the first 2 rows. You do your peremptories from those first 21 people, all right? Everybody else is called a supernumerary. You don't want to use one of your peremptories on someone who's not going to be in the jury pool anyway, so don't waste your time with anybody over
kind of
number
a
21.
classic rookie mistake.
And and what's funny is that's happened to me in 2 trials. The plaintiff did that, and they weren't rookies. I was pretty surprised they made that mistake. They struck juror number 23 or something like that. That was a waste of the peremptory. So
yeah, it's unfortunate.
all right, let's take a quick 5-minute break, and then
Doing whatever it is that he's doing. I'm gonna get started. The second half, we're gonna talk about the more exciting stuff, okay? I think the stuff that You know, those of us who want to live a life as trial lawyers, kind of live for, which is, you know, I mean, I didn't at the time, because I didn't know this was what I wanted to do, but I imagine, you know, if they had a class on trial strategy, you know, we could all sit in there dressed like Napoleon with little sticks moving troops around on a battlefield or something, like, okay, and then we're gonna come over here, and we're gonna do this. That's kind of the way I look at trial strategy. It's the big picture. The idea of being able to see, okay, what is it that matters about a particular case? And this kind of big picture view has allowed us sometimes to do things like, you know, if you look on our website, we've got a video from a guy we represented whose case was turned down by 9 other plaintiffs' attorneys before we took it on, and we got him, you know, a very large settlement based on what his injuries were, because we were able to see some of the nuances in the case that made it special. And seeing the things in people and in circumstances that make a case special, make it different from every other case that's like it, is what's going to give you the insight with trial strategy. I mean, you know, when I started thinking about this, I just wrote down in my notes, the first thing was, you know, why did you take this case? You know, what was the reason? Now, setting aside that impulse that we all have when we're getting started to just take any case that somebody wants us to do because, you know, we need the money or because we need something to do or whatever. But like, when you get to the point where you can decide whether you want to take a case or not, why did you decide to take this case? Was it because, you know, the facts of the liability were particularly appalling, and you figured that any jury who heard this would just, you know, fall out of their chairs? Was it the fact that, you know, it's a big company that's been, you know, arrogant about a particular issue, and now they're getting called on the carpet? Patrick's got a great story about.
Leave the big companies alone.
This one wasn't a big company. This was, I think, a school district maybe, where they were playing. A bunch of guys were playing football, and one of their players who wasn't there that day was walking by, and they invited him to come play. Of course, everybody else. This is high school. Everybody else has on pads and helmets. He doesn't. And so they go out there, and of course, he almost instantly gets horribly injured, like with this massive brain injury and all this other stuff. And Patrick's defending them, of course, because, you know, hey, you know, it's a lovable thing. I love that about Alan Dershowitz too. He'll take on cases that everybody else just thinks are garbage and make something out of them. So good for you. You're helping America. Okay. Not as good as Dersh, but you're in there. All right. So, you know, so this guy wants this horrible concussion. Well, Patrick's about ready to go to trial in like January or February. And the movie, I think it was entitled Concussion, with Will Smith, was coming out that December. And everybody in the media was talking about, you know, the NFL and concussions and how really dangerous football was, and how, you know, they didn't know if in 10 years there'd still be high school football because, you know, these kids was developing brains, getting knocked around. And in this climate, Patrick's about ready to go to trial and try and argue in favor of somebody who said, hey, you don't have any pads on, come on in, let's just do this. Just ram your head into these other people as hard as you can. You know, obviously that's when Patrick gets on the phone and says, we need to settle this case, please. I've seen the bigger picture and it is not good.
He jokes about it. I remember the night, it was like 11 o'clock at night, and
I was the one who told you. I was like, dude, you're really gonna try that case? Have you seen that movie? And you're like, what?
And I was like, oh.
I should have shut up. You would have tried the case. It'd been hilarious. Anyway, but you know, trial strategy is that great part where you look in and you say, all right, well, what is it about this? Now, there are some important things to remember, and some of this is going to be hard. So, you know, steel yourselves a little bit. You are not regular human beings. I hate to tell you, but one of the reasons why it's so difficult for us or you to predict exactly what a particular juror is going to think about a case is because we spent 3 years in law school being trained not to think about cases like our jurors, and then we've spent our careers looking at the world through those glasses. And so I can't stress enough the value of having people either in your office or at home, a significant other, boyfriend, girlfriend, whatever, who you can talk about, hey, you know, I got this case and blah, 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 blah. What do you think about this? What strikes you as important? You know, what, you know, and, you know, this case, for example, I keep using this case as an example, but it's just because it's fresh on my mind. This dog bite case we had, like I said, they had offered us something like $1,000, and then it went up to $2,000. I remember a couple of weeks before trial, I was talking it through with my wife, and I said, you know, here's kind of what happened, and you know, we said it wasn't a lot in the way of medical expenses, so we dropped those, and we're just proceeding on the emotional trauma to the child. Severe emotional trauma. I mean, like years of every time she sees a dog in the park, you know, sometimes she wets her pants, she freaks out, just goes nuts. All right. So really legit turns into a different person for like 3 hours. And I kind of soft pedaled that. I just said, well, you know, we're focusing mostly on the emotional trauma, that she's afraid of dogs now. And my wife said to me, well, you know, if she wasn't hurt that bad at the time, she's like, you know, I think $1,000 is about right. And I started talking to the other lawyers.
She slept on the couch that night.
No, I see, that's the difference between Patrick and I.
Bedroom when you get wiser.
Yeah, Patrick and I, that's one of the ways, see, I want to hear what bad stuff, that's why I asked those guys in Vardire, like, hey, tell me what you don't like, what you're prejudiced about. I want to know, because, and I want the other side, so this is either here or there, but, well, it comes into trial strategy. I want the other side to know exactly what my theory is, from way before trial. You should be coming up with these theories right as soon as you're taking the case, or you're deciding to take the case. But in this particular instance, I'll come back to that. You know, then I started to tell her, well, wait a minute. Here, let me tell you a little more about this emotional trauma, and I kind of laid out some of these facts, and you know, it's multiple instances over years, and this, and she said, that's where you're going to get your money. She's like, if you can help the jury understand that this is not just a normal situation where a kid got bit, didn't get infected, got cleaned up, went home, it healed, no, you know, very little scarring, fine, you know, gonna be fine. You help the jury to understand and to see this little girl as what she really is, what she's really gone through. That's where you're gonna get jurors that will open up. And so then we knew, and I talked to the other attorneys, and they went out and they talked to people that they knew and trusted and got kind of the same feedback. I mean, the initial valuations we got back from people were in the biggest was $5,000 range. And part of the reason we were trying the case was because the other side forced us to prove a point, because they wouldn't really negotiate with us very much, so we wound up having to go to trial. But you know, that kind of insight you're not going to pick up on your own. You're just not going to see, like, that I can't say she's emotionally traumatized and leave it at that, and have a jury just get into, oh, okay, that's what this means. No, I have to paint a picture. I have to lay it out. I have to show visually, you know, okay, here's the little girl, and you know, her parents get up on the stand and they testify about how vibrant she is, and you know, there's one story, I don't remember if it got told at trial or if it was just something we talked about before, but you know, this little girl would go running into like a Chili's or something and scream, I smell bacon, when she was gonna go get breakfast. I mean, just really out there. And then the juxtaposition with, okay, but how is she, you know, tell me an instance when she ran into a strange dog. Was she like that? And they talk about somebody who's hiding behind her parents and is begging to leave and is asking constantly whenever they're going somewhere, will there be strange dogs there? And, you know, has these reactions where she just curls up in the fetal position. And then even when they leave, isn't the same, you know, for 2 or 3 hours. get people thinking about, you can't ever ask the jury really to put themselves in your client's position, but inevitably, they're gonna think, what if that happened to my child? What if that had happened to my grandchild? And as you paint that more visual picture, because you have that nugget about, all right, what is special about this position? You can tailor your arguments to that. And I mean, it's very similar to that, to the kind of facetious example I made earlier with, Napoleon moving troops around on a little map. In those scenarios, there's always something special because there's always something different about the landscape. There's always some different area where, the troops could be drawn through, and then there's an ambush that comes off from the sides. There's always something different that makes it worth fighting the battle there. Otherwise, why are you doing it? And it's the same with these cases, is that if you can't articulate a strategy, then your strategy needs to be, how do I get out of this case as easily as possible? And I think where defense attorneys sometimes get into trouble is they either don't tell their clients that or their insurers, or they don't tell them early enough. And then they get towards trial and the lawyer's saying, hey, it's unlikely we're gonna win this. And the adjuster's saying, well, why are you just telling me this now? Suddenly, I've been getting rosy reports from you for 2 years. Why suddenly when there's a trial coming, you're telling me that we might lose $100,000? But with plaintiffs, it's getting out and understanding that when the case is large enough and you have the resources, focus groups, mostly your corporate defendants or your larger insurance companies or some of the larger plaintiff firms that have these kind of resources will be bringing in outside consultants and doing these really massive focus groups that can cost 30, 40 grand. I've run really great, statistically valid focus groups for $2,500. And that was with 3 different groups that we put through a little mini trial experience to get there, to watch them deliberate. And it gave us key insights to figure out, okay, what is it that's really going to make the difference to your average person? And they're never gonna tell you, things like a focus group or talking to relatives, they're never gonna tell you whether you're gonna win or lose, because that's gonna depend on the particular jurors you get that day. There's always some inherent variability in the jury, and you're never gonna get rid of the randomness of it. I can't tell you how many times clients have said, do you think I have a great case? And I say, yeah, I think it's a fantastic case. What do you think the chances we'll win a trial? And I'll say 60 or 70%. And they'll look at me and say, I thought you said I had a fantastic case. I said, yeah, you do. But that's as sure as I can ever be that we're gonna win, because we could get somebody who sneaks onto the jury, who doesn't like lawsuits, who get somebody who just doesn't like our key witnesses, or is having a bad day that day and has a forceful personality and convinces the rest of the jurors. So you can never really know, whether or not you're gonna win or exactly what the verdict is gonna be, but those kind of experience, whether it's a formal focus group where it's more valid statistically, scientifically, or more of an informal conversation with somebody that you know, that you trust, that is not a lawyer, that is not heavily involved in the legal process, can really nail down what are the things that are going to hang. For example, one of the things we figured out is the jury, if we're going to give them a bigger number, we needed to explain to them, why this number. We couldn't just say, we think our emotional trauma is worth $15,000. We had to say, look, this is a reasonable amount. It's basically $1,000 for every year from now until she turns 20. And her parents think she may need additional help and counseling in the future, and this will help her to get that, and will also help her, what is it worth to you if you go through your whole life with this kind of phobia and having to deal with it? What is that worth? To have this happen as a child, and then as you grow up. And I made the point over and over again that we weren't blaming the other side, that we weren't blaming their dog, and I think that calmed down the jury a little bit as well, because they didn't feel like they had to say they were bad in order to rule in our favor. But the juror mentioned, he said, over and over, everybody kept mentioning, well, it's just $1,000 a year until she turns 20. it's not, you know, that much money. And that, giving them that sticking point was enough to kind of push them over the top. So understanding critical elements of your case. I mean, your case, from when you first get the case and when you're deciding to take a case, it's important in that analysis that your brain gets past the traditional 3 pillars of, you know, why you would ever take an injury case. That's different with different kinds of law, but on the plaintiff personal injury side, it's, you know, what is the theory of liability? How good is it? What is, you know, are the damages big enough to justify, you know, what we're going to be doing? And is there some way that those damages are going to get paid? Those are all important questions, but you got to get beyond that. And in other cases, whatever your initial screening questions are, you got to get beyond that and say, all right, what is it about this case that speaks to me? What is about this case that makes me believe in it and makes me want to stand up there in front of a bunch of strangers and say, hey, this is important. This is why we're taking up your time. That's why, another reason why I have a kind of a policy, and I've, you know, heard it mentioned in a lot of different seminars, but it's something I really agree with. I don't get up and do this nonsense that a lot of lawyers do, where they get up and they spend a whole bunch of time thanking the jury or talking about their civic duty, or, you know, how they're being great Americans by doing this, because the jury doesn't care. What they want is they want to know that hook. Because that thing that is, I'm hoping, if I've done my job right, that thing that pulls me into the case, that gets me excited about the case, is the thing that they're going to catch on. Now, if they don't, we're probably going to lose. You know, if they can't catch on to our theory, if we can't teach our theory to the jury in a way that's compelling, in a way that helps them to understand and feel that same excitement, you know, somebody once said that jury trial is essentially competitive teaching. One side gets up and teaches, you know, their side's perspective on the facts, and the other side gets up and teaches theirs, and whichever one is most successful in teaching the jury wins, because juries tend to go with, you know, a narrative that makes logical sense. Okay, so obviously, if you think through your theory of the case and you realize that it's internally inconsistent, that fact A and fact B both need to be true in order for you to win, but fact A and fact B both can't be true at the same time, you have a problem. I mean, as lawyers, we can argue things in the alternative. Trial is very interesting because it forces us to do things that we don't. It's kind of like, you know, oh, I got it in the record. Okay, it doesn't matter that I don't think the jury understood, or it just kind of came out right as I was about ready to sit down. I got it in the record. That's not the thing at trial. We don't want to be up on appeal. We want to win. So what matters is, did that fact get communicated to the jury in a way that they heard it? They had it repeated to them, that it was driven home. They heard it, they knew why it was important, and you didn't beat it to death, but you made sure that it was always a part of the story. And if I can put in a pitch for some of our other CLEs in this series, we're going to show you how to do that when we get and talk about openings and closing arguments, and direct and cross-examination. We talk about how the use of effective cross-examination, for example, you can reinforce the theme, and you can pick out individual facts in a way that's not going to seem repetitive or annoying to the jury, and yet use those to build one upon the other until the ultimate conclusion you want the jury to reach from this witness is so unescapable that you don't even have to ask the witness the question, because the jury already knows what the question would be and what the answer would be, because it's what the answer has to be. And if the witness wants to argue with you, they're going to look like a fool or a liar. And when given the choice between saving their case or looking like an idiot in front of a bunch of strangers, every witness in the world is going to say, to hell with the case. I'm not going to stand up here in this formal setting. You know, what the modern day equivalent of standing up in the town square and say something that makes everybody think I'm a liar or think that I'm stupid. You know, they'd much rather just admit to the truth, even if it destroys their case at that point. So when you're looking at trial strategy, you need to look and consider all of these things. And really it comes from this fountain, this overwhelming obsession with this theory. And when I say theory, you take that thing that makes the case special, okay, that makes it unique, that makes it something that the jury's maybe not gonna do the same thing that they would normally do on a case like that. And you know, you work it into every part. You know, for example, the client that we had that you know, been turned away several times. He was a slip and fall. He'd broken his wrist, and the key factor was that he was at an extended stay motel because you know, he had been essentially homeless and was trying to find a job and was going on his way to a job fair. It was like 10 or 11 o'clock in the morning. It had been snowing since 6 in the morning. And they had come in and cleaned it out when they first got there at like 5 or 6, but they hadn't done it again. And so because these sidewalks that he slipped on went all the way around the hotel, we were able to make the argument that he was effectively trapped in the hotel, that he was at the mercy of this maintenance person as to whether or not he was going to encounter this dangerous condition or not. And the maintenance person was very dismissive about, well, you know, I have many things to do. I can't be out there shoveling all the time. People just have to watch out for themselves. And this sort of dismissive attitude combined with our client kind of trying to pull himself up by his bootstraps and trying to get, you know, work. And then afterwards, after he had the accident and he started asking them about insurance, suddenly his rent went way up at this place and they kicked him out and he had to live in his car for the next about 6 months. And when those facts came out, that was enough that I had one of the most hard-boiled defense guys that I know of come up to me and say, why haven't we settled this thing? We need to have negotiated on this a long time ago. I can't believe we haven't. And I said, well, we sent over a settlement offer. You guys just never responded. So I'm listening. And eventually we got, you know, what the client wanted. But part of it was because they could see it was coming and it would be bad. That's also another reason. A common tactic that you're going to hear is misleading. A lot of people will keep their cards really close to their vest throughout the case, apparently forgetting that 96 or 97% of cases in the United States settle before trial. So if you know there's a likelihood your case is going to settle because that's what your client wants, and then maybe what's in your client's best interest, why would you hide your theory of what you're going to do at trial from opposing counsel unless your theory sucks? And so when I get opposing counsel who's like won't tell me why they think they're going to be able to overcome some major hurdle, I think, okay, well, it's because they either don't know or the answer is bad and they just don't want to say. Because otherwise, you know, they would be forthright about it. And I understand the dynamics. I mean, Patrick here, you know, as much as I give him a hard time, a lot of times he doesn't have a choice over who he defends. He gets assigned cases, you know, by somebody else firm, by the insurance company, by a company, and they expect him to defend them. And he can, I mean, if you felt really that you couldn't defend a case in good conscience, you could back out of it, but mostly it's like, look, you're defending them whether you like it or not. I don't have that burden. I can sit back and say, well, I want this case, I don't really want that case. And so I can come in with a stable of cases where I'm like, look, I'm very confident in all of these cases, so what do you want to know?
See, and I'm a believer that, from the defense perspective, I'm a believer that regardless of your case, that's true. My case is the cards are dealt and I have to play with the cards that are dealt. But I'm a firm believer in that when it comes to theme, when it comes to your trial theme, you can always find a theme that resonates. And the beautiful part about it is Gabe mentioned it, if you saw it, when he talked about that slip and fall. He used the theme of he was a prisoner and he was at the mercy of the apartment complex. Those are just simple themes, but that's the themes that are effective. It doesn't have to be, if I see one overwhelming error in trials that just fall apart for the other side, it's because they tried to make their theme too complex. And themes,
or they didn't have a theme. They just tried to hit all. They took down the list of points they felt like they made at the depot, that makes the other side look stupid, and they
Try to
just
recreate the
just reread it. They just get the witnesses to say them again,
Yeah.
and not in any particular order. And they think, wow, man, we scored all these points, you know, and they're high-fiving each other when the jury comes back in and says, guess what, you lose. Because we couldn't figure out why anything you said mattered.
And I'm a firm believer that that's the difference between an attorney and a trial attorney. And a
Oh,
good
there's-
attorney, and that's why we get paid the
There's
big
a
bucks.
lot of differences between regular attorneys and trial attorneys.
Right.
Substance abuse problems, multiple moving violations, you know, crazily dangerous hobbies and habits, and
I'm not
yes,
using this as a therapy session.
adrenaline-seeking behavior. Yeah.
But anybody can recite the facts, anybody can present what happened. Where we get paid the big bucks is to come up with a theme that's gonna resonate, to wordsmith. We're gonna get into this in our examination CLE, but to pick words that resonate with it, you know, we'll get into, you want to pick words, you want to pick themes that come preloaded
Yeah.
with positions. You know, you want to pick those universal themes that everybody can adhere to. You know, justice and fairness, those get a little bit overplayed because they're a little bit more amorphous. But responsibility and accountability, those are the types of themes that resonate. And to get to those themes, you want to pick the right theme and you want to pick the right words that come preloaded with opinions.
And when you get to this, when you get to the point where you understand the basic rules of trial, which is kind of the bedrock goal of these CLEs, is to help you understand the basic rules of trial, so you could go in and do a basic, simple trial, you know, if it's your first trial, without embarrassing yourself or without missing, you know, some huge thing. When you get to the point where you understand those and you know your theme really well, okay, then you can start to do things like we're talking about, you know, which you should aspire to, and understanding there's a huge difference between me saying, you know, this little girl was scared for many years, and me saying, that little girl was terrified. And standing there for a minute and letting that sink in with the jury. After I've told them these stories, one's much more powerful than the other. But it's really hard to do that with your voice, with your face, with your, you know, your movements, if you're thinking, okay, oh shit, what's the rule? What can I say? What can I say? How do I do this? So as you move through the process of learning these trial skills, you get to be more comfortable. Okay? Your body, most people think that the reaction that you get when you get excited is adrenaline. Adrenaline actually only hits your system for a very short period of time, like 15, 20 seconds, not your heart explode. Then it gets replaced when you're in a nervous situation with a hormone called cortisol. Cortisol is really great if all you need to do is focus on, that's a bear, the bear wants to eat me, and I need to run faster than this guy so the bear doesn't eat me, right? But what it does is it directs energy away in your brain from higher order reasoning skills. Now, what do we need at trial in order to be following the rules, implementing our theme, you know, asking the right questions, keeping track of how the jury's responding, whether they're liking what we're doing, whether we're too over the top for them at that moment, whether they're impressed by something. You need higher order reasoning skills. You need to be able to go up to the bench and make an argument on an evidentiary issue, you know, in the middle of your opening, your closing, your cross, your direct, and then walk right back over and say, okay, as I was saying before, you know, let me ask you that question again, and just fire back at them. One of the things we discovered, for example, is, so I mentioned that one of our of-counsel attorney was second chairing the case, and he initially wanted to close. I pointed out to him that he might only have 20 minutes to prepare, and then he wisely decided he would prefer to open, which obviously you can prepare 4 months in advance. And so while he was opening, he did a very good job, and he did it without notes. But there were a couple of points, which is one thing that we'll advise, is learning to be able to speak on your feet. I mean, that's what trial work is. It's about being able to speak and think and make decisions on your feet as a lawyer, which is totally different than just about everything else we do as lawyers. You're usually sitting and talking on the phone, or you're writing something up. But trial is when you really get to be like, okay, well, you know what, actually I think that does come in because 803 sub 2 applies because this is a present sense impression, and this was an event that was described how it was being perceived, and so it's an exception to the hearsay rule. You know, and be able to do that kind of thing. In order to do that, you've got to practice, and you've got to be willing to get into court and get up and stand. But as you do that, you can add to, you know, layers and layers to your skills, and add to your themes. Things like word choice. I mean, which is better, scared or terrified? Right? Which is better, somebody was thrown from the car or somebody was hurled from the car?
And let me give you an example. I used it for anybody that was in the deposition. I think the deposition CLE, I might have used this. I'm going to trial on a case in the summertime where our facility has students there, and plaintiff was 17 and molested his 13-year-old roommate. And somehow the 17-year-old and his dad are suing us that we should have stopped him from doing this.
Can't imagine. They're upset their kid got molested? Gosh.
No.
Unreasonable.
He was the molest. That's the.
I know.
That's
I'm being sarcastic.
so. That's the point. Is when I was preparing for the deposition, and one of the wordsmithing that I'm going to use at the time of trial was everything in the paperwork talks about how this kid was a participant, but if you look at the police records, it's clear that he was the instigator. And so when I went in to depose his dad, I wordsmithed and I chose the word perpetrator. I refused to call his son by his name. I called. So when the perpetrator did this, and when the perpetrator did this, because what instantly comes to your mind when you hear that word? That word is so preloaded with feelings and with thoughts and with biases. You throw that out to a common person, you just made 10 arguments with one word.
And if I'm on the other side, you just alerted me that one of my motions in limine needs to be to prohibit counsel from using the word perpetrator at trial because this is not a criminal case.
Okay. And
I win that one.
All right, so.
What's the probative value?
But it worked because halfway through the deposition, the father stopped me and said, I'm really uncomfortable with you calling my kid the perpetrator. And I said, well, have you seen the police reports? Oh no, my attorney hasn't shown me that. Well, here, let me show you the police reports where the police officer says he's the perpetrator. And it's shifted it. Unfortunately, he's a California guy, expects California dollars, so it hasn't settled the case. But you could visibly see the shift in him, in his confidence in the validity of his case, because it was clear that his son and his attorney had been promoting this as, we're victims too. And that wordsmithing shift of no longer is a victim, now it's perpetrator. And in any case, with your theme, with your wordsmithing, you can find words like that. Like traumatized, like Gabe said it, traumatized instead of scared, right?
Or traumatized.
Those words just have so much more meaning to them and make such a bigger impact. And that's where we get paid the big bucks. Any investigator, any insurance investigator, any police investigator can get the facts and recite the facts back to somebody. Where we get paid is to turn those facts into something more powerful by the use of our themes, by the use of our word choice, something that makes it that
well,
much more powerful.
And it gets to be a lot of fun. And I guess I'm plugging our other CLEs, which you should all come to because they're amazing. I promise I don't let Patrick talk as much as we did today. We'll save you from that in the future. But you know, we get into some really fun stuff. I mean, there's like one of my favorites is when that gets objected to. Perpetrator, I don't think you'd get in because I think the judge would say, yeah, it's a criminal term. There's no, we're not dealing with criminal liability here. But you know, some other times when you're trying, the opposing counsel,
Instigator then.
See,
and that's my point. Is you can come up with multiple words that have those preloaded.
But the other way to do it is, you know, so let's say I'm doing a drunk driving case, and you know, I talk about, okay, so you guzzled 3 martinis, and then you went out to drive, you know, the kids home from scout camp, and they said, you know, Your Honor, we object to the word guzzled. You know, we think that's a loaded word, and it's not appropriate. And the judge agrees. Then you get up and say, all right, sir, you intentionally ingested into your body and into your bloodstream 1 martini, and now that's liquor mixed with liquor, right? That's how they make those? Because you don't want any, and they ice the glass, you don't want any water to interfere with your liquor, right? And you intentionally then, you asked, they came by and asked you if you wanted another, and you said, yes, bring me another, because you weren't done yet. And then you intentionally ingested that into your body and into your bloodstream, and and set that down back on the bar. And when they came back around, did you get up and leave at that point? No, you didn't. You said, I'll have another. And then you took that third one. Again, this is liquor mixed with liquor. And then you ingested that intentionally into your body and into your bloodstream. You do that right, by the end of it, you're going to say, please, let him say guzzle. Guzzled is good. Let's do guzzle. Because the clinical description of it, which you're never going to get an objection sustained, is often really bad. It's not as effective as the labels, but it's really bad. So you learn, when you have a good grasp, I guess the point in all of this is that when you have a good grasp of your theme and you know why the jury is going to be on your side, what particular points of your story do they need to understand in order to go with you, because you've done your research, you've talked to people, you've come up with it in your own mind, and you've thought it through and said, you know what, this is compelling, this is persuasive, and you talked with other people, and you've got that drilled into you. Mastery of these cases comes with the fact that if you're taking a case to trial, hopefully you've been marinating in this case for like a couple of years. And so by that time, you should know the facts of the case and what everybody said in depots better than the litigants themselves, better than the judge, better than anyone else. You and opposing counsel have been through every little detail of this case by that point. And you've got that combined with this organizational structure where you say, okay, cross, I know how to do that. Opening, I know how to do that. Direct, I know how to do that. Closing, I know how to do that. Then you can take that theme and then you can add in the level of strategy of being able to say, okay, let me list here on this piece of paper make one list of all the facts that we need to make sure we establish, and another one of the things that we need to really drill home, because these particular words, thoughts, ideas, facts will resonate with this jury, will help them overcome some sort of obstacle they have to finding in your favor. That's one of the things we felt in our dog bite trial, is we felt like the jurors were going to struggle with, who doesn't like dogs? Everybody likes dogs. So the jurors were going to struggle, and in fact, some of them indicated voir dire that they thought they might have a hard time. They might struggle with the concept of blaming this dog, because it had been inside its fence, and she stuck her hand into the fence, and they weren't necessarily supposed to do anything different with their dog. And so that was one of the reasons why we were really clear over and over and over again that, hey, we are not blaming them. We're not blaming the dog. The legislature has made this law so that it doesn't matter. Their actions have nothing to do with this case, and your verdict should not be a referendum on what you think of them, their dog, anybody else. It should just be, okay, and I had a verdict form blown up down, like, all right, what do we know? Did the plaintiff get bit by their dog? And I put a big X in it and went over the 8 pieces of evidence we had that was uncontested. And I'm like, okay, so you can do that. And then I spent probably 80 or 90% of my closing and the questions and the depositions. In the exams, I told our witnesses, look, I'm gonna go over the incident with you, but we're gonna get through that really fast, and then we're gonna spend all this time talking about damages, which is where the money is, where we're gonna convince them they need to go with it. We're gonna talk to them about these few things to help them get over the hurdles they need to award the money, and then we're gonna spend time on this, because trials ultimately become about what you spend time talking about during the trial. So I guess I'd encourage you, as you look at themes and come up with this as you take cases that you're thinking of taking to trial, to really study it from the get-go so that you understand that case, so that when you get to the point where you're looking at trial, you don't have to be scrambling around saying, okay, well, how do all these facts fit into our theme? What should we use? What should we not? I don't know. You already know that because you have this logical framework in your mind, and you can think, all right, well, how can I emphasize that point? You know, if I stop in the middle of my opening and I walk over behind my client and put my hand on their shoulder while I make this point about, you know, what good parents they've been and how they tried to prevent this incident, because again, they were trying to blame the mom. You know, what impact does that have on the jury? You know, it certainly keeps the jury more focused and awake because they see me moving around and they hear silence. They think something's going on. And you can do that if you have a good grasp. You know your strategy, you know your theme, you know where you're going from the very beginning. Then you start to add these layers upon layers of, all right, then we're gonna do this, and here's how this whole puzzle comes together to make a convincing argument. And I think with that, probably out of time, unless if you guys have any questions, feel free to come up afterwards, but we're probably gonna cut it off there. So thank you very much.